I'll go live right now. Okay, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Great, thank you and good morning. The first matter on our list this morning is 2021 P0491, John Doe number 21890 versus the Sex Offender Registry Board. My name is Justice Desmond. With me today is Justice Englander and Justice Hershfang will be your panel for this morning. As you're both familiar with oral argument here at the Appeals Court, you know you have 15 minutes each with no rebuttal. We've read your briefs and familiar with the record, so I would recommend getting right to your argument, but of course the 15 minutes is yours to use as you wish. That being said, Attorney Green.
Thank you. Good morning. May it please the court. Ashley Green representing Mr. Doe 21890. Mr. Doe's before you today is a 60-year-old man who has not committed a sexual offense in 40 years. He's been living in the community at the time of the hearing, which was in 2020, for 14 years. He underwent 24 years of sex offender treatment, and 16 years ago, he was deemed not sexually dangerous by qualified examiners. The SORB has classified my client as a level 2 moderate risk offender, and I submit at the end of these arguments, we ask this court to reverse that decision, finding that Mr. Doe presents, if any, a low risk to reoffend.
Now prior to his being a level 2, classified as a level 2, he was classified as a level 3, is that right?
That's correct. In 2006, he was released and then soon thereafter classified as a level 3.
And so when they had the reclassification hearing, he was reduced from 3 to 2. You say that he's 60 years old. At the time that they did the reclassification, he was only 58, is that right?
That's correct, yes.
Okay.
Can I just, I'm sorry, Attorney Green, since you've already been derailed by my colleague, just to follow up on the last aspect of Justice Desmond's question, and I suppose I should know this, but procedurally, is there anything that would bar your client from seeking reclassification again now that he's 60?
He would be eligible for reclassification in 1 year from now. So he was finally classified in 2020. And so every 3 years, they are my clients are eligible to petition for reclassification.
Thank you.
Counsel, you said that your client was deemed not sexually dangerous in 2006 by qualified examiners. Was that in the record?
Yes.
How was it put in the record? How was the evidence of the SDP trial put in the record?
My understanding that there wasn't a trial, there were 2 qualified examiners that came back after an evaluation and found him not sexually dangerous, and therefore he was released that day in March 2006.
So that's the way the statute works. If 2 qualified examiners determine not sexually dangerous, a jury trial is unnecessary?
That's my understanding. I don't handle civil commitments, but that is my understanding.
And so I did try to check, and I think I failed. The qualified examiners reports are in the record?
I can check. It has been a bit since I've gone through that record with a fine-tooth comb, but I can certainly find that for you.
Well, wouldn't that be like one of the most critical pieces of evidence that the hearing examiner ought to see?
Yes, I think that the overall opinion is critical. Yes. That he's not sexually dangerous.
Well, it's not just the opinion, right? I mean, it seems to me that your case and SORB's case is about the continuing risk of this particular person associated with events which took place, as you point out, I think it's almost 40 years ago now. And what two examiners found when they examined him and that had a consequence of him being released, it seems to me is incredibly important. And if it's not in the record, then that's problematic, it seems to me.
It is incredibly important. It's also my understanding, and I know that my brother will expound upon this, but it is the position of the SORB that their purpose is much different than the purpose of civil commitments in terms of the standard that they hold in classifying someone as a high risk or moderate risk sex offender is very different than whether or not somebody is a sexually dangerous person. Of course, my position would be that if somebody is deemed not sexually dangerous, you couldn't possibly hold them at the highest risk of being a high risk sex offender. But that is not the position of the board, from what I have learned. And therefore, we do not lay our cases upon findings of not SDP, because in my practice, I've learned that is not a winning argument before the board.
I understand that point, but on the other hand, your argument really is, look, 34 or 36 or however many years it is too darn long. And so, and you're making a sufficiency of the evidence argument, really, right?
I am.
Okay. And so one of the things I think would be important is whatever evidence there is to his continuing dangerousness. This seems to me to be, there isn't a whole lot of other evidence as to that, except for the fact that he's now been in the community for 14 years without an event.
Correct.
Well, so that being said, the hearing examiner considered the fact that he was found as a non-sexually dangerous person, right? That was one of the considerations when they went through the factors.
Ironically, it was found that he was found not sexually dangerous, but as my second argument points out, that's used as a risk elevating factor, a high risk elevating factor. That is the only way that this is brought into this assessment, which obviously is problematic. Factor 5 discusses whether or not somebody has been deemed a sexually dangerous person. It can only be applied as a high risk factor. It cannot be applied as a risk mitigating factor. In this case, factor 5 was brought into consideration by the hearing examiner because my client in 1985 was deemed a sexually dangerous person, and therefore that increases his risk to reoffense and his degree of danger. And that's how it was applied in this case.
Are you challenging the rationality of the factor 5? Are you challenging it? I did not read that in your brief.
In my brief, I argued that it was an error to apply factor 5 as a risk elevating factor in this specific case because he was then deemed non-sexually dangerous, and that occurred 14 years prior to the decision. So in this particular case, the application of factor 5 was an abuse of discretion. It may be in another case, factor 5 could be used as a high risk factor.
Does the hearing examiner have the discretion to ignore it?
The hearing examiner has the full discretion to apply factors as they deem fit.
Well, they have to consider all of the factors.
They do have to
as they apply to the particular offender. So my question is, if this factor, as has been approved by the legislature, if this factor applies, would it be error for the hearing examiner to dismiss it or ignore it?
No, because this factor doesn't, in this case, I submit this factor does not apply as a high risk factor as it is laid out in the SORB regulations.
So in other words, are you still going, Justice Desmond?
No, go ahead, please.
So I guess I'm trying to follow this train of argument, Attorney Green. So what would you have had the hearing examiner do here with respect to factor 5 and your client's previous adjudication as sexually dangerous.
In the assessment or in the analysis of the hearing examiner, it would be appropriate for factor 5 to be discussed in the decision, stating that in 1985, Mr. Doe was deemed a sexually dangerous person. Over the next 24 years, some on there, he went through sex offender treatment program. In 2006, Mr. Doe was deemed non-sexually dangerous. It has now been 14 years since that decision. Therefore, factor 5 does not apply. That would be the appropriate way to handle factor 5.
Is it within his discretion to say it doesn't apply? I'm not following that. Where does he get the authority to say that?
Because the underlying research for factor 5 indicates that if somebody is deemed a sexually dangerous person, or I don't have it in front of me, they then pose a higher risk to reoffend and a higher degree of danger to the community. However, the research doesn't say that if somebody was then deemed not sexually dangerous and was out in the community for 14 years. So you have to take the whole case. You can't just pinpoint one line in the record and say, therefore, factor 5 applies. That is an abuse of discretion that the hearing examiner made in this case.
Well, the hearing examiner considered factor 5 against 14 years of offense-free and a finding that he was now a not sexually dangerous person. Isn't that correct?
It is correct, but factor 5 should not have been applied as a risk elevating, as a high risk factor.
I understand your argument. Even if we were to ignore it, you still think you'd fall below a level 2?
I do. If I can kind of circle back just quickly, I want my argument to be focused on the time dependency of how these factors are applied, because this is coming up more and more often in that there are factors that are just applied as if everything just happened. And there hasn't been 40 years since that. And the scientific research, specifically by Dr. Carl Hansen, the 2013 article that is cited by the SORB regulations, specifically states that static factors or the offense history is important and it's valid, but it's time dependent. The propensity to sexually reoffend is time dependent. So as time goes on, the impact of those factors decreases. The problem with this hearing examiner's decision is that is not reflected in this decision and in this assessment.
Well, isn't it though? I mean, he talks about him being 58 years old, about how he gave him some mitigating weight for that, even though he hadn't reached 60. And he talked about that in the context of him being offense-free for the past 14 years.
He definitely mentioned it. It's just in the way that it's described, in the weight that's given to the different factors, it's not apparent that he gave enough weight to the mitigating factors.
That's a different question, right? I apologize, but how much weight he gives is really up to the hearing examiner.
But, and this goes into my third argument, which I know a lot of these kind of overlap, but without knowing how much weight was given to 15 separate factors, your honors cannot decide if this hearing examiner abused his discretion or not, and or reached that clear and convincing evidence standard or not. Because if the static factors, which are the factors that will never change, are given full weight, and the mitigating factors, which are the current factors right now in Mr. Doe's life, are given low weight, that is absolutely an error. But
there are no dynamic factors speaking towards him being more than a level 1, right? The only factors that are used here to make him a level 2 are static. We're talking about things, horrible things that happened 40 years ago. Can I ask that is factor 5 just a creature of regulation, or is it also in the statute that this language, whether he has been released or not, to present a substantial risk to reoffend? The board views any offender who has been adjudicated as an SDP, whether he has been released or not, to present a substantial risk to reoffend. Is that in the statute?
It's my understanding that it is taken from the statute. Whether he has been released or not, that doesn't make any sense because they wouldn't be classified. I mean, they wouldn't be classified in majority of cases whether they've been, if they haven't been released.
But the language is there to say it doesn't matter that he's been released. That's what that language is. And then the next language, to present a substantial risk to reoffend, if you take it literally, means he can't be a level 1 because a level 1 has a low risk of reoffense.
Yes.
That's why I'm asking if it's in the statute. I'm sorry, I should know the answer.
That's okay. I should know the answer as well. Unfortunately, I don't know the answer right now, but the issue that we have with Factor 5, and again, Factor 5 has its own issues. It doesn't come up very often, but it does come up. It also doesn't come up in a case as glaring as this one, where there have been so many decades that have gone by that we're kind of looking back and trying to decide what risk he actually holds today. I'm trying to base my argument in hard and fast research because it's so subjective. And so I want to point this court's, view towards the research that supports the SORB regulations. And I go back to that Hansen in 2013 article that says after 10 years that a high risk offender, which Mr. Doe was in 2006, after 10 years, they present a 4.2% risk to reoffend. And each 5 years thereafter, that is cut in half, which means at the time of the hearing, my client represented a 2% risk to sexually reoffend in the future. The hearing examiner cannot in good faith find him to be a moderate risk offender when it's a 2%. Now, I know there are obviously offsetting factors. The static factors offset that. But when it's been 40 years, those static factors are time dependent and they have to wane over time in how much weight they carry. In this case, my client has shown so many mitigating factors in his favor that deserve full weight because they're current, they're today. The static factors cannot be given full weight. And so I know that the court will say that he was reduced from a high risk to a moderate risk. So isn't that enough? Doesn't that show that the factors, the current factors are making an impact? And it does, but at the same time, my client doesn't know the difference between a level 3 and a level 2. He knows he is on the internet as a sex offender, period. And so it's so hard for me to explain to them that there is a difference. A level 3 is high and a level 2 is moderate. The public doesn't know that, and my client doesn't understand that. The impact to his life is the same. So, I'm happy to go on, but if there's no further questions, I rest on my brief. Thank you.
Hearing none, I think we'll move to Attorney Shania. Thank you very much. Your argument's been very helpful.
Thank you, Your Honor. If it pleases the court, David Shania for the board. I think on Factor 5, that factor is a statutory factor. The board is obligated by law to consider at any time that it exists. The only difference in the statute from the regulation is the word substantial risk. The statute says high risk for the statutory risk factors. And the board, when it promulgated, used the word substantial.
So is it the board's position that anyone who's been a sex offender and been released must be at least a level 2?
That's not the board's position. The board's position is the fact that they've been deemed sexually dangerous and released has to be considered. But again, and I think that the hearing examiner discusses that, is that the time that in the community, the sex offender treatment, the age of the individual can all ameliorate the high impact.
So has there ever been a case where someone who's sexually dangerous person and has been released has been determined to be a level 1?
That I don't know. I'm assuming that's possibly happened. I don't know because I don't do all of the cases and I don't see all of the decisions. I do know right now a large number of offenders are being dropped to either a 1 or being relieved based on the reclassification, based mostly on the time that's elapsed and the age of individuals, and that they're aging to a point where their risk and danger is no longer being considered to be even at a level 1. But whether or not that has involved any prior sexually dangerous persons, I can't tell the court that off the top of my head. I think that I would be guessing at that point. But my guess is it probably has happened because of the way that the number of individuals who are being taken off of or reduced to level 1s at this point has reached, at least in my recent experience in the last 2 years since the reclassifications have begun every 3 years.
Mr. Schneider,
So given that trend, do you think that this offender should be level 1?
Well, I think, and I think the hearing examiner does a good job with this of taking into account the nature of the sex offending behavior and taking into account the number of mitigating factors. Again, I think it's one of those situations where the hearing examiner made the decision. That decision should be given deference. But if this court were to see it differently, I don't personally think that would be extremely problematic. But again, we're dealing with a hearing examiner's decision, and the hearing examiner's decision was rationally based on the evidence and the factoring that was involved. And then you get to the point where are we, myself or the court, substituting its own judgment for a hearing examiner's decision that was rationally made and supported by substantial evidence. And again, I think as these cases come, and I think I brought it to the attention of my last hearing, we're getting more and more of these 3-year reclassifications where the sex offenses occurred a number of years ago. And I think that you're going to see more and more of these type of decisions where the courts are going to have to decide whether or not the hearing examiner's decision is rationally based and supported by substantial evidence, because a lot of these cases are becoming distant in time from the sex offending behavior. Now, like, for instance, the Hansen study that was cited by my sister counsel, that's based on group estimates. What the board's trying to do is find the individualized risk and danger. And I think even the Hansen studies that use the group estimates recognize that you still have to find the factors that impact each individual's cases. And in this case, the individual sex offending behavior and the fact that he was civilly committed at one time are big red flags. Now, again, the hearing examiner does a great job of taking into account all the positive strides he's made in the time that has elapsed.
The hearing examiner mentions every one of those things and then says level 2. And your sister says, but we don't know what weight was really given to any of that, because what it does is it gives us a litany of things and then just comes to a conclusion. Let me ask you this. If I could, remind me of the law with respect to challenging regulation. It has to be done in a special way, isn't that right? Like it has to be brought separately. Am I correct?
Well, it has to be a motion for declaratory judgment that has to be served on both the Attorney General and the board. It's taken as a separate course than an MJP. In Doe 10.
And do the cases say even if it were raised before us, we couldn't address it?
Well, if it's raised before you, you can always address the constitutionality of a regulation, but you got to look at
No,
the
we're not
fact.
talking about constitutionality. We're talking about rationality. I don't know if that's the same thing.
Well, I think you're talking about the same thing, if you're going to say that this statute does not bear a reasonable relation to the permissive or permissible.
I'm not about to say
objective.
anything. I'm just asking a question as to process, trying to find out whether the issue could even be before us right now.
Well, technically, it shouldn't be in front of you right now because it wasn't properly raised below.
Yeah, okay.
All right. So that being said, and I think reasonable minds may argue about whether or not the hearing examiner assessed certain weights to some of these factors, aside from those that have the weight associated with them almost by definition. But that being said, so here's an offender. I mean, let's really get to it. Who commits both offenses within like a 4-year period of time. He talks about where he was at that, and one of them while a juvenile, no less. He talks about where he was in his life, having been abused himself and wrestling with some other things in his own life. What he's learned in 20 years being committed, and he owns the conduct. So if we look past the horrendous nature, and no question, they were horrendous crimes, no question. But the whole scheme is designed so it's not a per se life sentence. Would you agree with that?
Yes, I would agree with that.
Yet it seems though, if we go through the analysis, how long ago since the offense really, and I think this is what Attorney Green is pointing out in large part, I would argue, is almost ignored. The fact that we say he's in the community for 14 years, but I think he was served 20 years without incident. Is that right? Is that in the record? When
yes.
He was a sexually committed person, 20 years without incident, 14 years in the community. The first offense as a juvenile, the last offense 40 years ago. Can any offender be a level 1?
Well, I think the quarrel is with the hearing examiner's decision. I don't think it's with the factoring or how factors work. It's whether or not the hearing examiner properly applied the factors. And again, it's up to this court to decide whether or not the hearing examiner's decision was based on substantial evidence or whether it was arbitrary and capricious and not properly based on the evidence presented. And that's within your realm to decide. Again, I don't think that you can say the way the board's factoring is set up necessarily is detrimental to an offender. It's the hearing examiner's decision making that you have to judge whether or not the hearing examiner properly decided the evidence, properly used the factors, and came up with the right decision.
So in essence, short of a finding that the hearing examiner was arbitrary and capricious, which I think would be a stretch on this record, we're bound by the decision regardless of the deference we have to show.
I think bound is probably too strong a term. I think you're supposed to give deference to the decision. Again, you give deference until that point where you believe that the decision is either arbitrary or capricious or not supported by substantial evidence. But bound, I think, is a little bit too strong a word for that. But I do believe that there should be deference given to the hearing examiner's decision-making process. And again, the appeals court, the Superior Court, and of course the SJC all have a right to rule against the hearing examiner's decision if it finds that the evidence doesn't support the decision or that the decision is arbitrary and capricious.
But if I hear you right, Attorney Shania, and also circling back to something you said earlier, in terms of the standard of review, if we were to decide as you, I think, indicated earlier, that this is a case in which the hearing examiner could have classified Mr. Doe as either a level 2 or a level 1 offender based on the evidence before him. Am I right to understand that if it could have gone either way, essentially the tie goes to the decision? Because if it could have gone either way, it was not arbitrary and capricious.
Well, let me put it this way. My opinion, of course, doesn't really bind the board in its decision-making or this hearing examiner. My personal feeling about this, and again, I think it was probably a much closer call, and maybe a year from now when he's over 60 years old, that may change when he goes back in front of the board. But you're right. If it's a close call, then really the hearing examiner's decision should be upheld.
And how, just if I may follow up quickly, what is the incentive structure there? I mean, as a hearing examiner, you're faced with someone who could either be classified up or down, someone whose name is going to be on the internet or isn't, and it's going to be your decision. Am I right to think that the incentive is always to over rather than under classify in a close case?
I wouldn't say that, because I've seen decisions in the past where they underclassified, and I scratch my head how they reached that decision. I've seen decisions where they've had the opposite. These are tough decisions for hearing examiners to make, and they don't take it lightly. They do really try hard to try to find the right answer. This isn't a type of prosecution. What we're trying to find is what is the fairest result for both the public safety issue and the offender.
The defendant testified here, right? Or the petitioner testified?
I believe so, yes.
Were the QE reports, were they in the record?
I believe the QE reports were in the record. The QE reports basically, and this is where it gets, and I think that's why Factor 5, the statute made it so imperative to have Factor 5. SDP is, as you know, is based on a different level. It's beyond a reasonable doubt. And you have to show, and in both of these cases, and this case is a good example, both qualified examiners, when he was released, said he no longer suffered from a mental abnormality that would indicate risk to reoffend. The board's regulations are not based on proven beyond a reasonable doubt that an individual has a mental abnormality and therefore should be classified. So there's a totally different process. So the fact that he was released as a sexually dangerous person doesn't exempt him from.
I understand that, but the evaluation is whether or not he's sexually dangerous, right?
Right.
That's the evaluation they make. And one of the findings that the hearing examiner has to make is as to his degree of dangerousness for sexual reoffense, right?
Correct.
Okay.
But again, the difference here is.
So to say to me that they're totally different, I struggle with that. A decision was made in 2006, 14 years before the hearing. He comes out and nothing happens for 14 years. Even the Hansen article that you guys rely on so substantially says after 10 years is a very substantial decrease in the risk of reoffense, right?
Right, which the hearing examiner credited him for.
So again, just to circle back for a second, you argued or you stated that your personal feeling really doesn't factor into this any more than our personal feeling factors into this. So where reasonable minds might differ, it's difficult to say that the finding was arbitrary or capricious. Do you agree with that?
I agree with that.
I see that's your time. Anything additional from the panel?
No, Your Honor. I believe that I've covered everything in my my brief, and I would rest on my brief at this point.
Anything additionally from the panel? Hearing none. Thank you both very much. It's been very helpful.
Thank you. Nice day.
Thank you.